Before we begin, I would like to thank Dr. Norman Royat, lecturer in law at Leicester Law School and founder and chief convener of the Global South Network, for organizing this weekly seminar series. I'm Hakeem Yusuf. I'm professor of global law at the School of Law, University of Derby, and convener of the Global South Network, University of Derby chapter. I'm chairing today's session. I work in comparative constitutional law with a lot of focus on the Commonwealth, and I also work in transitional justice and human rights, especially economic and social rights, as well as business and human rights. I have served previously, more than a decade ago now, as a commissioner on the Truth and Reconciliation Commission, Southwest Nigeria. And I also have had the privilege of being an expert advisor to government of the United States, government of Gibraltar, consulted for the International Commission of Juries. So I'm joined this afternoon by a discussant and a peer commentator for the session. Dr. Jashim Chowdhury is the discussant for the day's session. Dr. Chowdhury is a lecturer in law at the Hull Law School, University of Hull. His research interests include international human rights law, public international law, comparative law, and South Asian constitutionalism. Within the school and faculty in Hull there, Dr. Chowdhury contributes as a dignity and respect advisor, an equality, diversity, and inclusion champion, and the impact lead for the Ref 2029 circle for the Faculty of Law and Politics. Prior to joining all, Dr. Chowdhury held several academic positions in Bangladesh. He served as an associate professor at the University of Chittagong, as well as an assistant professor and senior lecturer at Northern University, Bangladesh. He also lectured at University of Information Technology and Sciences and Metropolitan University, all in Bangladesh. Brynne Guthrie is the peer commentator for the day's session. Brynne is a PhD student in the law school at the School of Law, London School of Economics. Our research explores the concept of legal continuity within the context of failed constitution-making processes, aiming to illuminate their broader implications for understandings of constitutionalism. Before joining the LSE, Brynne was a research fellow at the Max Planck Foundation for International Peace and the Rule of Law, that's in Germany. In this role, she advised constitution-making bodies in Chile and led research and capacity-building initiatives with judges and lawyers in Sri Lanka and the Maldives. She has also served as a law clerk at the Constitutional Court of South Africa and was previously a Google Policy Fellow. We are privileged to be able to host Yacine Ben Chaabane Mousli, who is a PhD candidate at the Law School of SciencesPo University, France. His research interests include comparative constitutional law, the evolution of constitutionalism, particularly in the Arab world, and critical legal studies. His ongoing PhD research focuses on decolonial theory and constitutional law. Today, he will be presenting his PhD project titled Decolonial Theory and Constitutional Law. So, yes, and you have between 30 to 35 minutes for your presentation, and this will be followed by 5 minutes for comments or questions from both the discussant and peer commentator each. If time permits, we'll then have a 15-minute question and answer session with attendees.
So that's for this introduction. Thanks everyone. I'm feeling very privileged to present my the current state of my research. Thanks especially to Norman for running after me and inviting me for presenting my PhD. So I'm at the end of my first year. I focused mainly during my master's and my PhD on constitutionalism in the Arab world, especially in Tunisia. And the question that rose in Tunisia post-2011 led me step by step to address decolonial theory and constitutional law. So I'll present what I mean by decolonizing constitutional law, and I focused mainly this year on the conceptual aspect, the theoretical framework, and I'll still give some empirical findings as well. So first, As an introduction, I'd like to present the decolonial theory and locate it in the broader discussions on postcolonial studies, subaltern studies, and decolonial theory. So usually when I present decolonial theory, I don't like to stress what distinguishes it from the other train of thoughts. I see it more as a dialogue between all those trends. And postcolonial studies emerged with Edward Said and Orientalism. Then we talk with Spivak and Chakrabarty about subaltern studies. And decolonial theory continues this discussion, putting emphasis on epistemology and knowledge. Most importantly, the decolonial scholars emerged from South America, and they take the South American colonial experience as a base for their theories. And taking the South American space as a context, it allows them to expand the historical framework. And instead of starting to study decolonialism from the 18th, 19th century, they start in 1492. And by having this longer historical framework, it allows them to see coloniality as the dark force behind modernity. And they have a more critical approach to modernity than postcolonial scholars, for example, especially because they have this longer historical framework, because they saw that modernity, when it came to South America, it brought with it coloniality. So they say that both of them are the two faces of the same coin, and that the modernity is the dark side, the dark force of modernity. So this is for the historical framework on decolonial theory. And in my research, decolonial theory actually it irrigated many aspects in socio-legal studies and philosophy. They also renewed our conceptions of race, of gender, by putting emphasis on the colonial imposition of such notions. But my focus in my PhD is mainly about these four notions I put: coloniality, modernity, delinking, and pluriversality. I also can talk about epistemic disobedience, about border thinking, about race, gender, but I chose those first four notions because I find they have a specific relevance to area constitutional law. So coloniality is the epistemology of colonialism. That's what allows and creates the conceptual framework of colonialism and neo-colonialism. It's epistemology and what justifies it and legitimizes colonialism, and also create a hierarchy between the people and between the system of knowledge. Modernity, as I presented it, is the other side of coloniality, and the first group of researchers around decolonial theory is called modernity coloniality, and they're centered around Duke University with Walter Mignolo and Catherine Walsh. So delinking, as presented by Walter Mignolo, consists in detaching ourselves from the Eurocentric system of knowledge and put in and value other knowledges, more specifically indigenous kind of knowledge. So it's delinking from the Eurocentric and Western views of the law or of knowledge taken more generally. And pluriversality is contrast with universality. Decolonial theory is very critical on the Enlightenment, and instead of the universalist view, decolonial theory praises, on the contrary, to admit many different views of the world and many different cosmologies. My area I study is constitutional law, understood broadly. What I mean by that is, first, I focus on state constitutional law from the state, and then I also look into infra-constitutionalism and supra-constitutionalism. When we talk about the state, the first big question is whether the modern nation state is a colonial institution or not, and can a constitution decolonize the nation state paradigm? Because on the one hand, the nation state protects territorial sovereignty, has also this sacred vision of a unitary people. So all those elements tend to oppress indigenous people and further neoliberalism and the colonial economic system, more specifically extractivism in South America. So this is what the challenge that I have to face when I engage with constitutional law. And then when I talk about supraconstitutionalism and infraconstitutionalism, first it's the human rights treaties, especially the African Charter and the American Charter, as legal treaties that emanated from global South spaces, try to present them as materially constitutional, and to look at them to what extent they can produce decolonial change on the ground. And for infraconstitutionalism, I refer here to Gunther and auto-constitutionalism and the creation of constitutions outside of the state. One thing that's important for decolonial theory is the notion of interculturality, interlegality, and how a same individual, the same community is interfered with many normative systems. So my area is still specific to constitutional law. So I'm not trying to address this as an anthropologist, and not as a sociologist either. It's not my discipline, and moreover, I don't want to be another colonial observer. But I just try to see to what extent the Constitution can be a space of plural normativities. Does the Constitution allow a plurality of normativities and give a space to other legal norms, even if they're not enshrined in the Constitution itself? On the conditions of my research, the question is what makes it possible. First is the southern turn in comparative constitutional law. In this effort to provincialize Europe, I have to take seriously constitutional experiences from the global South, and doing my PhD in a northern institution, that I have to delink myself, detach from the usual suspects, and do constitutional law outside of the US, France, and Germany. So the first effort to make my research possible is to take seriously constitutions from the global South. And then I present hybridity as a framework. Why? Because, as I said earlier, the state is can be seen as a colonial institution, and not only the state, but law itself emerged from the Enlightenment, from the West. And I put here the Bainan on law as a Eurocentric enterprise. The entire way of thinking as a lawyer can be seen as colonial, because of the objectivation, abstractation, the deduction. All those tools are the tools of colonial mind. But on the other hand, there is also the decolonial options, and I can see in many instances, in many places around the world, South Africa, South America, constitutional law addressing the colonial question and trying to repair the colonial history. So on the one hand, I have this, we observe this new phenomenon on constitution addressing the colonial question and trying to repair inequalities that are consequential to colonialism, but also all those notions of decolonial theory, coloniality, universality, allows me to enhance, to better understand the decolonial constitutional reform. For example, when we see that the Constitution of Ecuador, Bolivia declare the countries as plurinational states, the tools of decolonial theory allows me to better understand them, to place them in a network of meaning, where the plurinational state can be better understood through the notion of pluriversality as described by decolonial theory. So I take hybridity as a framework, but I justify it, and I build methodologically on pragmatism. So it takes me to my next part, where is the decolonial law. One major difficulty I faced this year is the question of knowledge, the question of qualification. Basically, how can I recognize a decolonial norm? When I see a constitution, when I read it, how can I distinguish between the colonial and the decolonial norm inside? My first inspiration was to look into feminist legal theory, critical race theory, to see in those fields how they can declare a norm, a decision, a court decision, feminist or not, addressing racism or not. I found some answers with William James and pragmatism. Here I highlighted that the pragmatic method is primarily a method of settling metaphysical disputes that otherwise might be interminable. And going back to the previous question on is a state inherently colonial, is a constitution inherently colonial, rather than staying blocked and curtailed by this contradiction, the pragmatist approach that focuses more on the effects and the consequences allows me to build upon this contradiction rather than fall under it. And on the other hand, the prototype theory by Eleanor Roche is also helpful for me to construct methodologically my. Eleanor Roche is a psychologist from the 1970s, I think, and she proposed this prototype theory to counteract a little bit Aristotle and Platon kind of methodology where they set criteria to define an object. And prototype theory, rather than seeing an object through its criteria, we can find a prototype and then see how much we can other objects can look like it. For example, here there's the bird, and you can see many other instances of bird, and depending on they can share some characteristic and not others. So this is helpful because it allows me to classify decolonial norms rather than having a binary view between colonial decolonial. This incremental approach allows me to classify decolonial legal norms. With that perspective, it allows me to put both pluri-sovereignty and, for example, references of Islam in the Arab world, where some of them are more decolonial than others. Because, for example, if we consider that the reference to Islam in Iran, for example, is decolonial because it's undoing the colonial legacy, yet it's still harmful for women's rights or minorities' rights. So it would count as decolonial, but far from the center. Whereas pluri-sovereignty or giving constitutional rights to the indigenous people would be closer to the center. So this is a visualization of how I present decolonial norms. So now, now that we identified them, how do we explain them? So the first, if we take like a chronological approach, first we can observe decolonial constitution making. I took the two most recent examples. In Chile, the indigenous people were included in the constituent process. It was between 2020 and 2022, I think. And last year there was an amendment to the Australian Federal Constitution that tried to recognize indigenous sovereignty. I was not lucky because both of them were rejected. But I am referencing here to the article by Merino on constitution making in the Andes, where he shows how both constitutions of Ecuador in 2008 and Bolivia in 2009 were trying to address the colonial question, and it shaped really the political struggles in the constitution making process. Then we also observe that indigenous people are also included in the norm-making process in many countries, and most strikingly in Bolivia. Some seats in the Senate, for example, are reserved for indigenous people. So it allows them to have this prior consultation and participate in the elaboration of norms, and also they're also present in the Bolivian Constitutional Court. And this is a concretization, this is an application of the idea of pluri-sovereignty. Because in a single state, in a single chamber, you can find multiple sources of sovereignty: territorial, elective, and indigenous. Another phenomenon of decolonial constitutionalism is the translation of indigenous notions, indigenous concepts to constitutional law. For example, very famously, the notion of vivir bien is enshrined in both Constitution of Bolivia and in Ecuador. And what's interesting is this inscription of indigenous notions gives a leverage to judges then to promote fundamental rights and better protect the environment. And this leads me to the role of judges in decolonizing the law. Here is the example of Ecuador, where the concepts of rights of nature allowed judges to give more protective environmental decisions. In a different continent, in Kenya, the judge also struck down one article of the criminal code that prohibited what they called subversive speech, and the Kenyan Supreme Court saw it as a colonial legacy, and because it's the subversive speech is basically targeting the critique of government. And so the Kenyan Supreme Court identified it as a colonial legacy and protected freedom of speech. But the other side of this story is also the Constitution is the place where is enshrined the state control over natural resources, for example, in Ecuador and Bolivia. So the same constitutional text can be progressive on one side and promoting extractivism on the other. And so the Constitution itself is a space of struggle, of semantic struggle, but on the ground as well, the judges and political actors are also in a struggle of which constitutional norm to apply. And this is the pitfalls or the limit of decolonial constitutionalism, because as much as they recognize, for example, indigenous sovereignty, it is also curtailed by the developmentalism and the protection of liberty of trading and of enterprise. And what's the story and the history? Basically, here I try to situate decolonial constitutionalism in the history of and the expansion of constitutionalism around the globe. First, to go from decolonial constitutional law to decolonial constitutionalism, I believe there is some kind of public awareness, also scholarship efforts to recognize decolonial constitutionalism outside of the individual states, but see it more as a culture, as a global phenomenon. So because it's a ongoing process led by South American countries, I believe we can start talking about decolonial constitutionalism. Now the question distinguishes itself from transformative constitutionalism and from global constitutionalism. Transformative constitutionalism is also a very recurrent talk in constitutional law, where there is this belief that constitution can change and shape society and change it for the better by changing mentalities, social relations, etc. My argument is decolonial constitutionalism goes further, and by recognizing indigenous people's rights and not stop to the multicultural level, basically. great examples of transformative constitutionalism are usually India, South Africa, but also Brazil, Colombia, and Peru. And here the excerpt from Merino as well shows how there is a deeper commitment to indigenous rights of self-determination and social demand to subvert the neoliberal economy. So I feel there is a new step forward with decolonial constitutionalism, and if constitutions needed to enter the new phase, it means that transformative constitutionalism was also failed in some way. And then the other idea is that decolonial constitutionalism proposes a subversion of global constitutionalism. I put here the article by Bruce Ackerman, where he shows that constitution and constitutionalism tend to be globalized, and we have this convergence from almost all constitutions from around the globe, where they share common language, common values, and but are very much blind to the implicit economic and social elitism that lies behind. And my idea is that decolonial constitutionalism subverts global constitutionalism, and instead of universal and unique global constitutionalism, decolonial effort tries to admit that there can be a family and pluriversal understanding of constitutionalism. And then my other concerns, legal theory more specifically and constitutional theory. My idea is to what extent does decolonial theory subverts important notions of constitutional theory, of constitutional paradigms. For example, key concepts like state, like sovereignty, like people. How much can decolonial theory contribute to the to this discussion by reinventing and proposing alternative to those definitions? Then the other question is also the usefulness of decolonial constitutionalism, because the paradox, the continued paradox throughout my presentation is to relord the master's tool is can we deconstruct master's house with the master's tool? And this is a big question of decolonial constitutionalism. Is the constitution is still the main tool to achieve those social demands? We can talk later about my opinion on this question, but I think it's almost time to conclude. So just to finish, what I tried to achieve in my PhD is to give some kind of exhaustive inventory of decolonial initiatives in constitutional law, and try to present some results on how it is affecting constitutional law and the core paradigms of constitutional law. So this is a bit the two challenges and objectives of my PhD. Thank you.
Thank you very much. That was spot on. I would, without taking more time, call on Jashim to speak as a discussant for 3 to 5 minutes.
Thank you, Hakeem, and thank you, Riyad. So I don't think that I'll take that much time, because from what I have heard so far, it's Yacine's project is sort of shaping, and it looks like that the ultimate conclusion that Yacine may come to, or the ultimate finding or theoretical proposition that Yacine may come out at the end of the project is still it will take time to shape, I believe. So from what I have heard so far is these are very, very important theoretical questions, and very curious and interesting conceptual framework that Yacine is dealing with. So it's very important and it's very, very, very consequential, I believe it's going to be. So based on what I've heard, I would not raise any discussion, because these are all the theories that are being applied. Particularly, I found it interesting when he was talking about how do we discover which are the decolonial norm I'm looking for into different constitutions. So at that point, what I came to what came to my particular attention is William James's pragmatism, lens of pragmatism. He wants to apply that to see what consequences a particular constitutional provision brings in practice, and from there whether it can be identified as a decolonial norm or is it just a colonial continuation. So that is one thing. And another, Yacine is trying to apply his prototype theory, just trying to see how the particular provisions of a particular constitution looks like a prototype of a colonial provision. Yeah. So these are the two things Yacine is applying to identify in the constitutions he is perhaps studying, to see what are those colonial norms. So I understand that as the research moves on, he will be able to identify more. Currently, I have seen at least he has identified mostly the constitutions that deal with the indigenous sovereignty, the participation of the indigenous people in the constitution making, and state control over the natural resources, like those types of things. So apart from that, so I understand that there will be more decolonial norms that are will be invented as the research goes on. But one thing struck my mind when Yacine was talking about that. It was sort of when Yacine was talking about Iran, to identify how Iran is sponsoring or patronizing or showcasing an example of decolonial constitutional provisions, particular reference to by referencing to the state position of Islam within the Islamic Republic of Iran. So Yacine identified it as a decolonial norm. I understand that he has applied that pragmatic lens from William James, that it is decolonial because it talks about Islam, which is not Eurocentric, which is not from the West. Understandably, that is indigenous to Iran, Persian and Arab, that type part of the world. But what struck my mind is that when Yacine was talking about, he says that, oh, it's good, it's decolonial, but it's harmful for minority rights. And then I was thinking, what? Why? Why, when we see that Islam is good, it's decolonial, but Islam is harmful for minority rights? On what basis? Is this, I understand that perhaps this is the consequence that he is trying to look into the Islamic inclusion of Islam in Iranian constitution as a decolonial norm, but in consequence, it subverts minority rights. I was thinking on, oh, is Yacine or we all falling in the same trap of colonial constitutional thinking, that Islam is anti-minority rights? Is it based on some presupposition, or is it based on some actual facts or consequences that we see in the ground reality? So there's always that risk, I feel, that whenever whichever lens, theoretical lens or approach or standard or heuristic you apply to identify which are the decolonial norms, and you find something decolonial, oh, consequentially, no, it's harmful. So who is telling us that it's harmful? Is it that same colonial thinking with which Yacine and we all are fighting continuously? I think are we falling into that same trap? That is one question. Yes, again, not review, not discussion, not comments. Just I understand that Yacine's thought process is in the development stage. So obviously, when he goes on, he will sort of think about those, whether I am falling into the trap of the same thing which I am trying to fight with. Okay, then another thing that came to my mind, I'll be very brief because this paper is very theoretical, this project is, and this theoretical discussion in this type of programs, it's very sometimes it becomes monotonous and people lose interest. So I'll try to keep it more simple and easy and practical. Then another thing, what I was thinking about is Yacine is perhaps saying that we are looking into Global South. But whatever I have found so far is examples mostly based on Latin America. And I got example from Ecuador, Bolivia, Australia, Kenya. A very passing reference to India. So what do we mean by global South? Do we go to that post-colonial states in the Southeast Asia? Do they count as a global South? Or do some of their constitutional norms, provisions, and systems or propositions or theories they are proposing, do they come into the purview of this dissertation or is in this project?
Yacine, because of time, I see you have noted those. Can we go to Brynne so that she also gives her contribution, and then you have the opportunity to respond as far as you can, and if you can take a few questions. Brynne.
Okay, thank you so much, Yacine. It was really, really interesting to listen to your research, and I think it's going to be a fantastic project, so congratulations. I think what I wanted to talk about is really the fact that in an age of modernity, we also unfortunately live in an age of the modern constitution, right? Where the modern constitution is one that is characterized by its written form, by this kind of veneration of the text itself that almost makes it seem as if it's a kind of near-permanent, semi-permanent structure that is going to be kind of tinkered with rather than a living document. And this semi-permanent structure then is one that's obviously enforced by courts that kind of assume this guardianship role. And I think that when you have that paradigm and you try and fit the then decolonial theory into that paradigm, it can sometimes run into a couple of problems or a couple of difficulties. And I wanted to speak about some that I thought might be interesting for you to also then address, perhaps even in your thesis, as a potential sort of limitations of subsuming the two paradigms into one. So for instance, when thinking about plurinationality, right, we can think about plurinationality as existing in many levels. So it would exist, of course, at the level of government, where you think about representation, for instance, of Indigenous people in the courts or representation of Indigenous people in Parliament. But in reality, plurinationality happens in the day-to-day interactions between people, right? And this idea, very often the kind of liberal modern ideas of law that we have are ones that are perhaps not in tune with Indigenous lines of thinking, right? So what often happens when you think about plurinationality is it gets subsumed into modernist frameworks, right? So I think Ecuador is a fantastic example where they have, rules for representation in the constitutional text, but and rules regarding representation in political bodies. But if you look at implementation on the ground, so how the law interacts with everyday people, right? So how it, for instance, regulates relations between Indigenous and non-Indigenous people, how it creates structures of power in the day-to-day, that implementation hasn't happened. And even though many years after the enactment of the Ecuadorian constitution, we're still waiting for the legislation that's needed to kind of implement that day-to-day interaction. And then the question becomes, why do we even need legislation to implement that if this is really a plurinational, society? So I think thinking about how the Constitution relates to the materialist conditions that underpin all of this is going to be really important, because the thing about colonialism is that often the people that it oppresses continue to be oppressed under the new framework as well, and so struggle to then have their voices heard in shaping those frameworks. And that kind of leads me to the second point that I wanted to make about constitution making. So my kind of pet project, but I think that often in constitution making processes, the inclusion of Indigenous voices can itself become a form of fetishization rather than a form of empowerment. And we need to think about how we include people to make sure that their, voices are actually heard. So I think South Africa is an interesting example, right, where constitution making is politics, right? Like we frame it as law, but it's politics. And so there are always going to be trade-offs that end up being made between different parties and different organizations with different levels of power. And Indigenous people often end up being the ones with the smallest amount of power. So the South African constitution, right, we have 11 official languages. Not one of them is the official indigenous language of the country. It's interesting, right? And you'll find a lot of scholars in South Africa themselves who argue that the constitution is not a decolonial project, but rather a continuation of the colonial project. And if you look at Chile, where yes, they had fantastic representation of Indigenous people within the actual constitution making body, but because it was politics, they found ways ways to almost veto those voices and silence those voices at the end of the day. So I think it's what this project perhaps needs is more of a link between the Constitution as a written document that we venerate and think of as something that can bring about salvation. And of course, transformative constitutionalism and all of that is interesting in doing that, but how that actually relates to the material conditions on the ground and the politics of constitution, because I think that will give us perhaps a clearer lens to think about what decoloniality actually looks like when you think about it, its impacts on the ground. So yeah, thank you very much. And I think it's a really fantastic project.
Thank you so much, Brynne. That was, again, on time. We are still doing good for time. Yes, Yacine, do you want to respond in about 5 minutes?
Okay, 5 minutes. Yeah, of course. Thanks a lot for those challenging questions. I'm very happy to answer them now, and also happy to continue the conversation by email on whatever social media platform. So the question about how to classify the morality and how to classify norms as decolonial or not, I have many answers. First, I think when I try to detach myself from the current state of the debate around decolonial theory, when I say that the norm is decolonial, I don't attach it to any kind of moral value. It is a bit wishful thinking from my part. I know that there's some kind of morality in it, but I try to have more of a scientific and neutral. And on the other side, I know that decolonial theory and decolonizing methodologies invite researchers to embrace this moral aspect of research, and doing a research not as the Weberian kind of neutral researcher, but also to engage with the people who you're working with if you're doing research on the ground, and to be mindful of what your research is doing and who you are addressing. So this is kind of somehow late in my internal debate on morality with my research. When it comes to the example of Iran, it is a difficult example for me because as a Tunisian, I don't share the same vision of Islam as them. I grew up like in a completely different society. So actually, like I wouldn't even classify it as decolonial if it was like a personal opinion. But I try in my research to be as inclusive as possible, and that's also why the prototype theory is helpful, because it allows me to have as big of a sample as possible. But I agree with you that the main issue with this methodology is it's highly controversial, and it's very much open to refutation. And if I claim it's bad consequence, someone else can claim that it has positive effects. But I do think that I need to assess better how to evaluate the consequences. And then what to call the Global South, I try to be the most inclusive as I can. Because my objective is to be exhaustive and to bring some kind of inventory of all decolonial initiatives. So for me, the Global South is understood very broadly, and my focus on South America is because they are the main laboratory where those decolonial initiatives are taking place, constitutionally speaking. But then with of course, Southeast Asia and Africa also count as the Global South. My question is how to analyze them through a decolonial constitutional law perspective. But I feel like it's more doctrinal than empirical, than constitutional talk. And then about materialism, I completely agree with you. And actually, I think it's my big project for my next year, because as a Marxist myself, I tend to also like to focus on materialism and how it's affecting people on the ground. And this is like also conversations I'm having with colleagues and with economic PhD in my universities. I also like to have this transdisciplinary research project where I can take care of the law and the other researcher takes care of the economy side, and this meeting of multiple skills and different research focus can produce an interdisciplinary research.
Thank you very much. We'll take a quick question from Zulfia.
Hi, thank you so much, Yacine. I hope I'm saying that correct. It's something which I love, because I'm working on decolonial theory, and it's not easy to work on. And I'm going to drop you an email separately. Just a quick question on a personal level and also on a professional level. How easy do you find yourself doing research on decolonial theory, especially when the epistemology is very well dominated by Western vernacular? And just expound on that, the example of Iran, for example, and also the idea of minorities, no matter what the human rights language kind of takes over. So how do you deal with those challenges? Thank you.
Thanks a lot for your question. I do feel, so I'm Tunisian, but I did all my training in France, and I'm doing my research in France. Despite growing up in Tunisia, my legal mind is very much forged into French academia standards, and also if I want to publish my PhD or if I want to continue in academia, I still have to follow those constraints. Now, how do I do it personally is first learning other languages, and most of the decolonial theory is written in Spanish and Portuguese. Also, I'm very privileged to have an exchange program in my PhD, so I'll spend next year in Bogota at University of Los Andes. So I think, when we talk about methodological, to go far away from our theoretical framework, we have also to move physically in a way. So that's why I'm doing this exchange in Bogota, and also like to participate in seminar research activities with the PhDs there and other students, because I guess my questions and the way I formulate them are very much from Global North or North institution. So I'm really curious to see how people, for example, who started learning law in 2015, a few years after the plurinational constitution, how do they learn law? How do they teach it? And what are the questions that come for them? So I try to translate in a different continent in order to better understand their way of thinking, and hopefully in my when I will start writing it, I'll try to write it not from a kind of perfect neutral researcher, but write it as from someone who emanates from this context.
Thank you.
Thank you very much. Thank you, Yacine, for an insightful presentation of your project, which seems to be a great contribution to the wider literature on decolonial theory and constitutional law. Many thanks to Jashim and Brynne, and to everyone who attended this session. The GlobalSouth network warmly welcomes PhD students from any discipline and any part of the world to share their projects and receive interdisciplinary feedback. Anyone interested in presenting their work or participating in a session can contact Dr. Nouman Royat, the founder and the convener of the GlobalSouth network, at the email address provided in the chat box. Same time next week, let's meet our next speaker, Gabriel Omachi, PhD candidate at the Open University Law School, who will present their PhD project titled Gender and Sexuality Bias in Nigeria, a Colonial and Religious Importation. Take care, look after yourselves, and have a wonderful rest of the day.
Thanks a lot.
Bye. Thank you very much.
Thank you very much.
Thank you all.
Bye.
Thank you.